Regular meeting of the Homelessness and Poverty Committee of the Los Angeles City Council. I'm joined by Council members Jose Huizar and Mike Bonin. My name is Marquise Harris Dawson. I'm the chair of the committee. We have two items for today's agenda. One is a closed session item and one is an open session item. And I believe that we, as a matter of necessity, have to take the closed session item first. We'll ask the deputies to clear the room so we can go into closed session. We have one item in closed session, folks, that we have to discuss privately, and then we'll have a second item that we'll invite you back for.
Item number one is a city attorney report relative to the ongoing litigation regarding the case of Racer versus City of Los Angeles. The committee shall recess to closed session pursuant to Government Code Section 54956.9 D1 to confer with its legal counsel relative to the case entitled Racer versus City of Los Angeles, 9th Circuit Court case number 15-55487. This matter involves ongoing litigation relating to the above referenced case concerning Los Angeles Municipal Code Section 85.02.
So we staff of committee members and the various departments that will be reporting to us. My mic went off because we're in closed session. Is that why that's happening? I know, right? Yeah. It was terrific 10 seconds ago. It was fantastic. Joined by Councilmember Kern Price. All right. Are we set? Excellent. Thank you. So as folks are re-entering the room for our regular meeting, we will start the meeting with public comment. So I'll leave a couple of minutes for folks to submit public comment cards. I have a few in front of me that we'll start with. But if you want to make general public comment to this on issues pertaining to and in the jurisdiction of this committee, but not on the agenda, you should submit a card within the next couple of minutes or so. We have public comment cards, and we'll ask you to come to the mic. Beth Kempf and Craig R.
I'd like to welcome you all to Garcettiville. This message is for this board and for Mayor Garcetti. 1 year ago, Mayor Garcetti announced a homeless state of emergency on the steps of City Hall. Today, community groups from across Los Angeles gathered on those very same steps to demand emergency public health resources in Skid Row and an end to the ongoing criminalization of homelessness throughout the city. We want to highlight that the support for Prop HHH, the $1.2 billion bond measure to build permanent supportive housing in November's ballot, must be coupled with an immediate end of the enforcement of laws that lead to the citation and arrest of homeless residents. Furthermore, critical emergency responses like restrooms, water stations, and trash cans are urgently needed throughout the city, especially in Skid Row. The city cannot continue to harm those in the streets today because they are hoping to build homes for tomorrow. Street homelessness is up 20% as of the last homeless count, and those numbers aren't even accurate. and the recent targeting of homeless individuals through the enforcement of laws like 5611 only continue the city's de facto approach to addressing homelessness criminalization. Until Prop HHH passes and permanent supportive houses units are actually built, you must provide emergency public health resources, stop the enforcement of laws that largely punish homeless individuals simply for being homeless. This type of enforcement for largely nonviolent quality of life violations is not only cruel, but it can make it even harder for the cited and arrested residents off the streets to get into housing programs. We support Prop HH and all long-term plans that will end homelessness. We hope voters will pass the measure in November, but we need solutions from you today. This is from LA Ken, LA Human Rights to Housing Collective, Hunger Action LA, Black Lives Matter Los Angeles, and the Stop LAPD Spying Coalition, amongst others.
Thank you. Craig, Aaron, we're going to close. We're not going to receive any more public comment cards from here, but Craig, thank you.
Yes. It's my turn?
Yes, sir.
Thank you. Craig Roberts, Los Angeles Community Action Network, resident of the row. Today we held a press conference and did a press release on the one-year anniversary, of course, dealing with the mayor and the city council's rhetorical reference to a state of emergency. After a year of inaction, other than hoping that hoping to pass the responsibility for everything on to the public by having them pass HHH, we'd like to review with you the fact that the Homeless and Poverty Committee should be doing more, like supporting our demand for mobile public health infrastructure that includes adequate restrooms, showers, and water stations located in Skid Row. We hear a lot of talk about people who are compassionate about the homeless and who want to do the right thing, but we don't see it out on the street. I live on the Nickel. I live on 5th Street in the heart of Skid Row, and we never see this action. What we see instead is the smash and grab techniques of LAPD. We see, of course, instead the harassment, and that's all I can really call it, of Operation Healthy Streets, where after the sanitation department and LAPD comes through and quote unquote washes down the sidewalk and the streets, it's often dirtier than when they started, leaving puddles of dirty water and filth and scum all over the sidewalk and all over the street. Now, that's quite a contradiction. You send in the sanitation department to sanitize, and it looks worse after they're there than it does before. So that's why we're asking for cleaning supplies for the residents to do their own cleaning, because they have a vested interest in keeping stuff clean. So we hope you'll support these kinds of demands for cleaning supplies and for mobile infrastructure and all the things that will make life livable for the people who are unfortunately houseless and on the street. And you know our motto, MHG, house keys, not handcuffs.
Thank you. All right, Mr. Clerk, can you read item number 2 into the record?
Certainly, sir. Item number 2 is a city attorney report and ordinance relative to potential repeal and or replacement of Section 85.02 of the Los Angeles Municipal Code prohibiting the use of streets and public parking lots for habitation.
Excellent, thank you. I think we have Mr. Dave Michelson here to report on this item.
Good afternoon, council members. David Michelson with the City Attorney's Office. Here with me also is Adrian Corsani, also with the City Attorney's Office. We're pleased to be with you here this afternoon, here discussing the Los Angeles Municipal Code 8502, dwelling in vehicles. As the committee knows, Some time back, the Ninth Circuit Court of Appeals ruled as unconstitutional the city's current 8502. The city attorney's office, at the request of council, transmitted a while ago a number of alternative draft ordinances that would replace 8502, one that had, in essence, an outright prohibition of vehicle dwelling overnight, I believe between the hours of 9 p.m. and 6 a.m., and an alternative version that would allow limited vehicle dwelling between 9 p.m. and 6 a.m. On certain streets, non-residential streets primarily. A number of months ago, the city attorney's office transmitted another report, this time with a repeal only of 8502. We were last in front of your committee, I believe, in April. Towards the end of the committee meeting, there was recommendations made by the committee yet to be heard by full council. And we're here today to answer any questions and to assist in any way that we can.
So, questions, colleagues? Mr. Bonin?
Okay, I've got several. First of all, let me ask about just sort of the general language of what's prohibited. So remind me, if you can, what the courts found objectionable in the Desert Rain decision. If I recall correctly, and correct me if I'm wrong, please, it was that our definition was vague and that it was being applied in a discriminatory manner just towards homeless people. Am I correct?
Well, more or less, the court found that some of the words used in the existing 8502 were unconstitutionally vague and ambiguous. Words like no overnight, day by day, parking or otherwise. Without definitions, without more specificity, the court believed that the public would not have enough information to go on as to what was being prohibited. So the court essentially was telling the city of Los Angeles, the words you're using in your existing law are not precise enough, they're not clear enough, they're vague and ambiguous, and therefore making the ordinance not constitutional.
And what did the courts have to say about how the ordinance was being applied?
You know, it's been a couple of years. I don't recall precisely the court's discussion as to the actual application. I can't recall whether the court had any concerns with an as-applied, with as-applying the ordinance to individuals that were stopped on the street for vehicle dwelling. But I believe that was one of the allegations in the lawsuit. We can go back and like I said, it's been a number of years and certainly report back to you with.
Yeah, I mean it's a little foundational for me on whether or not I can vote for this, because I certainly know that was one of the allegations as applied. One of the facts in the case, as I recall, was that there was a situation where officers enforcing the ordinance told someone they could not dwell or sleep in their vehicle, and they asked where they could go, and they were told to go on the sidewalk, which is, honest to God, that's the perverse reality of how we do things in Los Angeles, but that was one of the facts in the case. My understanding was that it was also a question of how it was applied, that the purposes of these ordinances originally, when they came online in the 70s in all the coastal cities or so, was to prohibit folks from illegally camping in coastal communities rather than going to beach campgrounds. So I thought that was one of the cases. So one of the issues in the ruling, and I'd like to know more about that certainly before it comes to council. I probably won't vote yes until I know more about that.
Right, Council Member, I should add that nothing in the court opinion precluded the city of Los Angeles from adopting an ordinance regulating vehicle dwelling as long as the city did it in a constitutional fashion. So the court did not say in any way, shape, or form that the city, you do not have the ability to prohibit or regulate vehicle dwelling. No, you said if you're going to do it, you've got to do it even-handed, so there's no discriminatory application, absolutely, and that the words themselves have to be understandable.
Well, and okay, So the discriminatory application is essentially...
That's right. The city should never be engaged in discriminatory application of any of its laws, including this. Agreed.
Got it. So I don't remember who was here from City Attorney's Office last time we discussed this, but I asked a series of questions. And I used myself as an example, and I talked about what the inside of my vehicle looked like as the father of a young child who has changes of clothes in the car, all sorts of food in the car and all that. And I was told, don't worry, council member, you wouldn't get cited for this. And then I further refined it and said, well, let's say I was parked in front of Gold's Gym in Venice, where there are a lot of RVs in Venice historically. Well, don't worry, council member, you wouldn't get cited for this. And I said, what if I were taking a nap? It was, don't worry, council member, you wouldn't get cited for this. And so my question is, I think whoever was answering the question, I don't recall who it was trying to reassure me that I wouldn't get cited. But that wasn't my point at all. My point was, if I wouldn't get cited for it, then we were looking at applying it in an unconstitutional and discriminatory way.
Again, the city and its law enforcement officers, with the training that they receive, know not to discriminate in terms of how they apply laws. So we rely upon LAPD doing its job and doing its job well. For instance, the two versions that the city attorney transmitted well over a year ago, the city attorney believed then and believes today are constitutional the way they're written, on their face. As long as they're applied in a constitutional fashion, they should be able to withstand judicial scrutiny. And both those two versions I think A and B, had elements of prohibiting and regulating vehicle dwelling on city streets, on residential streets and other streets. Again, we believe then and we believe today that those two versions are constitutional on its face and can be applied constitutionally in an even-handed way.
So let me ask you this then. If I were in a vehicle that had changes of clothes, that had food in it, that looked sort of lived in, because my car is fairly unkempt, and I were in a neighborhood that has a lot of RVs in it, and I were, as I sometimes have done, rarely, but have done, taking a cat nap between meetings in my car, and an officer walked by, should I or should I not be cited for violation of a revised 8502?
So I've got in front of me one of the two versions that we had transmitted, and it has a number of components that guides LAPD and police enforcement agencies in handling these situations. So first off, it's in light of all the circumstances. So officers are trained as to what that means. They are to look for two indicia. First, I should actually back up. It's between 9 p.m. and 6 a.m. So it's not during the day. It's between 9 p.m. and 6 a.m. Let's assume it's on a residential street. And a vehicle's parked on the side of the road. It's got an occupant in it after 9 p.m. The occupant is engaged in one or more of the following, either preparing or cooking meals or sleeping. And also inside the vehicle are contents not traditionally associated with ordinary vehicle use. And I'm reading here out of the draft: sleeping bags, bedrolls, blankets, sheet, pillow, kitchen utensils, cookware, cooking equipment, bodily fluids, storing of personal possessions or belongings that obscure some or all of the vehicle's windows. So if that's the contents of the vehicle, if a person in that vehicle is either cooking meals or sleeping, and in the totality of the circumstances that the officer finds after 9 p.m., yes, that would be considered a potential violation of the code, assuming that this ordinance were to be adopted.
Tell me a little bit more about the totality of the circumstances, because that's, I think, where we get vague and things get iffy.
Right. It's to give appropriate law enforcement discretion to a police officer in applying this particular law. When they pull up to a vehicle and get out, they've got some specific objective criteria to adhere to. And in applying those objective criteria, they need to consider everything that's before them and the circumstances. And this is how they traditionally would apply many of the laws that are on the books.
All right, that still concerns me.
Okay, fair enough.
Because I think that's where we start getting into not applying it in an even-handed manner. I understand why that's in there,
right.
But I'm just trying to, because I've lived with this situation in the 11th District my current job, my previous job for a long time, and I'm concerned about how that applies and whether or not we just wind up in court again. Let me ask about the other aspects of it. So if we were to say that there are places in the city where it's okay to dwell overnight and places where it is not, if we were to say it's not okay in front of schools, residences, daycare centers, but it is okay everywhere else, that leaves, I think, more than half the city which is available. I think less than half of the city is zoned residential.
I don't know the percentages, but that sounds roughly,
So,
could be correct, yes.
Certainly an enormous percentage of
It's
the
certainly a
city.
significant number of streets, I would assume.
What level of protection or defense does that give the city to a charge of criminalizing homelessness?
So I guess two responses. One response would be that in the two versions that were transmitted, and I think the version that was more recently considered in terms of modification, a violation would be subject to a ticket, an infraction, with some dollar amount associated with it, in an effort not to criminalize homelessness. That or something similar to that certainly would still probably be a component, I would assume, what council would adopt. In addition to that, again, there's no court ruling that we're aware of that ties the city's hands in actually prohibiting outright vehicle dwelling. We're not necessarily suggesting that. Council's not entertaining that. But certainly there's no court decision we're aware of that actually comes out and says that. So this is a far cry from certainly a complete prohibition, a complete ban. But again, we're not saying that that would be unconstitutional in and of itself. So leaving open a fair number of streets to be available for vehicle dwelling, from a legal perspective, we believe would pass judicial scrutiny.
Okay, I mean, because you can look at it glass half full, glass half empty. Mm-hmm. You know, you can say, as some folks did, and I think as some of the newspapers reported, the city considers new ban on vehicle dwelling. You can also look at it from the other perspective. For the first time, the city is saying there's X percentage of our streets, whether it's 40 or 50%, where vehicle dwelling is okay, and X percent where it's not okay. And if we have 4,000 or so, by some estimates, vehicles with people living in them, then we've provided significantly more than 4,000 spaces by saying it's okay in commercial or industrial.
Well, depending on what the final version of the ordinance looks like, excuse me, to be adopted by council, there could be a significant segment of city streets that would be available for vehicle dwelling between 9 p.m. and 6 a.m. That's right.
That's all I got for now, Mr. Chairman. Thank you.
Thank you so much, Mr. Bonin. Mr. Price?
This is modeled after something that's occurring in some other jurisdictions. How firm a ground are we legally in terms of potential challenges?
Well, there's no precluding individuals or organizations from legally challenging the city if it were to adopt a new ordinance trying to address this issue. Many cities and municipalities in California, maybe I shouldn't say many, certainly some municipalities in California still have on their books language that is roughly similar to what the city of LA had. So those municipalities and their ordinances are probably in peril, quite frankly. I'm not aware of, and I don't think my colleagues are aware of, any specific municipalities that have gone down the path that's being considered, I think, by the city of Los Angeles to provide some flexibility with allowing people to vehicle dwell on certain streets. So there's no specific example I can point to. I can't tell you that Seattle or San Francisco or New York has done this. There may be some out there that we're not aware of, but that would, we're just not aware of those other municipalities having gone down this path. We have drawn upon language that we see in other case law and other circumstances in order to craft the draft ordinances that we have provided, which is why we believe they are constitutionally sound. But they could be subject to a legal test in court. We will defend that. And we believe, again, that these are constitutional means to address the issue.
Thank you.
Thank you all for the work that you've done on this matter. I have a couple of questions that haven't quite been articulated clearly, to me at least. So what is the material difference between what we've been advised to repeal and what's been suggested that we send to the council for adoption?
So the language in 8502 that the Ninth Circuit reviewed and ruled as unconstitutional, and it's short, and I'll read it to you. No person shall use a vehicle parked or standing upon any city street or upon any parking lot owned by the City of Los Angeles and under the control of the city or under the control of the County Department of Beaches and Harbors. And here's the operative words: as living quarters, either overnight, day by day, or otherwise. And I'll repeat that last part. As living quarters, either overnight, day by day, or otherwise. And the court took issue with those words as words that were not defined, vague, ambiguous, and the words that we have baked into the two versions we previously transmitted as alternative means to replace 8502 are words that we believe people can get their arms around. They can understand what it is that they're being prohibited from doing, where they can do it, where they cannot do it. So we've spent, I would say, a fair bit of time in crafting language that we think addresses the concerns of the Ninth Circuit.
Thank you. Second question. So you talked about a citation, which my understanding of at least, but I hope you would shed some light on this, is different than a misdemeanor, right? So I can receive a misdemeanor as an individual. If I park my car in the wrong place, I get a parking citation, which has different long-term implications should I be unable to meet the financial demand of that.
Right. So these laws all sit in the city's municipal code, and by default, any violation of the city's municipal code is a misdemeanor. A misdemeanor is a criminal sanction under the law, just like felony is. Felony is roughly more than a year potential in jail. Misdemeanor is up to a year. However, there are certain provisions of the municipal code that are established not to be penalized as misdemeanors. They are infractions. They are citations, whether it's jaywalking, getting a speeding ticket, and what has been prepared in these draft ordinances are sort of a penalty schedule. The infractions would be punishable by citation, by a fine, similar to jaywalking, speeding ticket.
So what is the distinction between, because I believe there's an important distinction, between a parking violation, which I've got lots of parking tickets, I've never been called to court, and a misdemeanor where you can be called to court?
All right, so a misdemeanor occurs when a law enforcement entity finds a violation under the city's municipal code. They may make an arrest associated with that. Prosecution may be initiated by prosecutors in the city attorney's office with respect to misdemeanors. Those are cases in the criminal courthouse. We've got a judge, you've got a defendant represented by counsel. It could be a public defender or a private lawyer. You've got the prosecutor, again, typically from the city attorney's office. And the misdemeanor case is prosecuted to resolution one way or another. And potentially, if there's a conviction, of course, there would be criminal history associated with that. An infraction is a citation, in essence, where someone receives a ticket for violating the municipal code. The infraction often has, if not always, some dollar amount associated with it as a penalty that has to be paid. The city recently, within the last 2 years, I should say, embarked upon the Administrative Citation Enforcement Program, the ACE program, which is sort of an alternative version to the traditional infraction or traditional citation program, which involves the superior courts. So currently, under the ACE program, the Administrative Citation Enforcement Program, which is administered by the city attorney's office, officers of the LAPD can write an ACE citation for many violations of the municipal code, drinking in public, for instance. And the violator would be handed the citation under the ACE program. And it would have, as the first infraction, I think, $250. It doesn't have to be set at that, but many of them are set at that amount initially. And the person who's violated has an opportunity to pay it or to challenge it, including through an administrative hearing if necessary. That program is a pilot program. It's fully implemented at LAPD and also with Department of Animal Services. It's been quite a success. Potentially, 8502, a vehicle dwelling violation, could be, its enforcement could also be done through ACE, maybe with a different penalty schedule with lower dollar amounts, but that's an opportunity as well.
So I guess what I'm asking is, one, it has to do with criminalization of sleeping in a car, but it's actually a finer point about dealing with the problem. So as I understand a misdemeanor, you cite someone for the misdemeanor, you send them a fine, and if a person's sleeping in their car, the idea that they're going to pay a fine is not logical, but so you play that, so the fine increases, and they still don't pay it. Eventually, a bench warrant goes out for their arrest. Is that how this works?
Well, I'm not a criminal prosecutor myself. I'm on the civil side of the office, so I don't want to speculate as to what that process is. I don't know if we have any of our prosecutors in the office. Julie, do you have any knowledge on that?
That's what happens. That's what happens. I have enough experience with this. On the other hand, a parking citation is against the car, right? And the citation may increase in the demand, but the remedy is to take the car. They don't ever take the human being.
Yeah, there's no prospect of jail time associated with receiving a citation that's an infraction. It's got a monetary amount associated with it. So under that scenario, I don't know how there would be the prospect of anything more than that. But again, I'm not a prosecutor, so I'm not going to speak to that.
All right, so we've got some public comment cards that I want to take if there are no comments from my colleagues. Yes, sir, Mr. Bonin.
I just wanted to follow up with Mr. Michelson. I'm still a little stuck on the totality of circumstances. Can you point to other ordinances where we have similar language?
You know, I cannot offhand. The idea of including that language was to provide as much flexibility as possible so that officers would be able to perform their duties and evaluate the situation before them. And they're trained to do that. So that's why that language is there. We can go back and see if that language appears in other muni code provisions. It might, just off the top of my head, I don't know.
That's troubling me.
Fair enough. And again, these were two initial drafts, alternatives that were provided. We anticipated and expected dialogue with council about that and about all the issues associated with these two drafts and further refinement and changes, some of them material and significant, others maybe less so, would take place. So this is part of that process.
I mean, and it troubles me to the extent that I don't know if my recollection is correct on whether or not the court found that our application of the ordinance was also problematic. If they did, then having something in there that leaves so much leeway for how it is applied concerns me because I think we're traveling down the same road.
Right. My recollection, and it's a bit vague admittedly, is that when the Ninth Circuit acted a couple years ago, because the language in the existing 8502 was frankly, and I just read it, so you all heard it yourselves, relatively vague and ambiguous without definition, it lent itself to difficulties in enforcement as well, and then the potential for possibly uneven enforcement. So I think that was a focus of the court that was relatively unique to that type of language. The language that we're suggesting has got a lot more, you would say, almost meat on the bones, much more definition, more readily available for application with objective criteria and certainty. So I would hope that would not repeat itself because of that.
Although I think totality of circumstances is such a vague thing, it opens up that can of worms.
Fair enough. We'll absolutely look at that again.
Excellent. If there are no other comments, we will go to public comment on item number 2. I have 3 cards in front of me. Jovo Smith, Beth Kempf, and Becky Dennison. 1 minute each, please. Yes, sir.
Jojo Smith. Yeah.
Jojo, sorry.
Here we are again, creating ordinances to criminalize. If y'all want to get away from criminalize, you need to stop letting the city create these ordinances, and you need to say no, because a person don't have a house, they should be able to live in their car. Like, they pay property tax on their tag. It's a tax. They pay tax. So we need to stop creating lawsuits in this city and start helping people that are homeless. Because you know if this goes past, y'all will be in court. The people will be suing the city of Los Angeles. So we need to stop taking the people's money, because it's not the city's money, it's the people's money. Because it don't come out of y'all's pocket, so y'all ain't worried about it. But it comes out of taxpayers' dollars. And we need to put more money into the city than taken away from the city.
Beth Kempf, and please forgive me if I'm mispronouncing your last name.
It's really concerning to me that the guy from the city attorney's office didn't really know any other laws to talk about and didn't know how this would be prosecuted. As Jojo said, if people have their cars taken away, that means they have their homes taken away. And I live on Skid Row in a tent. If any of you have ever spent time on Skid Row, which by some of the dirty looks I'm getting, I'd assume not, you would see it's not an easy life. And if you try to live anywhere else in the city in a tent, because the Jones settlement doesn't apply, it's pretty much impossible. Right now, you talk about how it's not going to recriminalize people, but two people who weren't homeless, Keisha Michael and Mark Quinton Sandlin, were killed in their car just last February because they were sleeping off getting drunk rather than drinking and driving. So you're putting more people in danger by not allowing them to sleep in their cars. And as you know, Jojo said, this is something that's already being taxed. When you pay your yearly taxes, they tax you on your car. So people are paying taxes to live in this city. And if you further criminalize people, they will never get out of poverty.
Hello, I'm Becky Dennison with Venice Community Housing. I had a bunch of other things to say, but I just have to respond to the city attorney, who I believe sits up here and misleads you over and over again. I will say there were at least 5 attorneys here last time who said they would absolutely sue on either version of the ordinance because they would be read as unconstitutional. They have a 100% rate in winning on those issues. There's just no doubt about it, because the argument last time was about vague and ambiguous. The argument this time will be about no viable alternatives, right? So it's not, the legal argument won't be the same. I also think you better ask the criminal side of the city attorney's office to be here. There is a firewall, so I'm not saying you should know these things, but if a law's in the municipal code, they have the option to charge as an infraction or a misdemeanor. We saw under the past city attorney, who was the worst criminalization city attorney we've seen in a long time, every single one was charged as a misdemeanor. So this city attorney may have the intent of charging as infractions, but in the future they can charge any way they want. And you absolutely can go to jail on an unpaid infraction. We saw it massively under the Safer Cities Initiative, jaywalking tickets, and the most arrested offense was for failure to appear. Failure to appear on an infraction is a misdemeanor offense. So this is, no matter what, a criminalization ordinance. You guys should repeal 8502. You should move forward with safe parking. It's a great idea. A lot of people would benefit from it. And not pass any new ordinance until there are viable alternatives, until there is housing for everybody. And I'll tell you that if it's passed, the absolute exact same thing will happen. It'll either be you can move your car to Lincoln Boulevard, or you can get out and sleep on the sidewalk. And some people will get out and sleep on the sidewalk. So what are we doing to people? This is ridiculous. You should repeal. You should not pass either version of this ordinance. Thank you.
Ms. Dennison, there's a question for you.
Becky, I want to ask a question. I wanted to ask about the viability thing. This isn't me doing devil's advocate. This is sort of a genuine question. The viable alternatives thing, I think, is absolutely crucial. If if the city is saying that 50% of the streets are okay to park and dwell on, isn't that to a certain extent a viable alternative?
Well, as you know, I'm not a lawyer. Sometimes I feel like I am, but I'm not. So I can only go by what the analysis was the first time, that it would not hold up as viable alternatives. I think it's going to depend on the area of the city and the way that the law is enforced, right? So if a certain neighborhood is targeted, that has less, so I think that's the problem, is that in certain neighborhoods that would probably be true, but not across the board.
Okay, thanks.
If there's no further discussions, I have some instructions in front of me that we'll ask to be adopted. Number one, receive and file the June 22nd, 2016 Homelessness and Poverty Committee recommendation and report, and provide the following new recommendations that incorporates many of the directives of the June 22nd committee action. Number two, adopt the city attorney's draft ordinances that repeals section 85.02 of the Los Angeles Municipal Code in its entirety. Number three, request the city attorney to prepare and present a new draft ordinance that replaces LA Metropolitan Code section 85.02 with a version that prohibits the use of vehicles for dwelling according to the following. A, between the hours of 9 p.m. and 6 a.m. on residential streets in the city, which includes any streets that adjoins one or more residential, single, or multifamily residences. B, between the hours of 9 p.m. and 6 a.m. on a street within 500 feet of any school, preschool, or daycare facility or park. C, between the hours of 2 a.m. and 5 a.m. on any street with a posted sign prohibiting overnight parking. 4, sunset the provisions of the ordinance so that it will be repealed on July 1, 2018, unless extended by ordinance. 5, include in the draft ordinance the utilization of the city's ACE program for enforcement of violations of LAMC 8502, whereby the first violation will be cited by LAPD as an ACE citation with a $25 fine, and subsequent violations will escalate to a $50 fine for the second violation and $75 for all subsequent violations. 6, request LAPD and DOT to work with the city attorney and to work on a penalty structure that provides a first-time warning. We'll ask that we get report backs to this committee on how we can incorporate this in the near future. Got it?
Yes, sir.
Questions, comments on that? If not, yes, sir.
So thank you, Mr. Chairman, for the recommendations. It's a dense read, and so I want to explain how I understand it, especially for some of the members of the audience. Some of the members of the audience will remember that at the last meeting, I proposed something similar, where I had sort of an A and a B. My A was prohibit living in your vehicle on residential streets or near schools. Allow it elsewhere, which I still think might be a viable alternative. I also had in there a provision where the city council could prohibit, even on commercial or industrial streets, if there was a critical mass of safe parking in that council district or that area. So that part of it about prohibiting on all streets in tandem with the safe parking program isn't part of the recommendation. My understanding is that the safe parking program is still going to be coming forward. City Attorney is still working on it, and we'll be hearing it next month. Is that correct?
Well, I think it's the CAO and CLA that have been working on it. We've certainly been assisting council member, absolutely.
Okay. So the safe parking program is still alive, still is moving forward. The question of prohibiting vehicular living on all streets in Los Angeles, on commercial and industrial, for the moment is dead. That's off the table. That's not part of this proposal, and it's not part of the standalone safe parking program coming forward. So I like these recommendations. I think we have a balance to strike. And I think the city of Los Angeles has done a horrible job in this regard. I think in terms of street strategy in general, the question of what do we do about people who are homeless, how do we help them, and how do we deal with the neighborhood consequences prior to the sufficient construction of affordable housing, I think we've done a remarkably poor job on. I think absent a safe parking program, we're still being sort of half-assed about it, because if we say you can't park on these streets, you can park on these streets, that's an improvement over where we were, which said you can't park anywhere. That's an improvement. For the first time, the city of Los Angeles will be saying something that it hasn't said. It will be saying, yes, you can park here. And that's been our problem on all of the street elements in Los Angeles, is we have never said yes to a certain location, whether it's storage, whether it's bathrooms, whether it's encampments, whether it's housing. We just don't say yes to any places, so the default is anywhere. And the city loses its regulatory power, and everybody deals with the consequences. So I'm very much okay with the idea of saying yes here and no here. I just want to indicate, though, that unless we do a safe parking program, all we're doing is managing the problem differently, because rather than solving the problem. Safe parking, you're connected with services. You're on a pathway to housing. You have a voucher. You have access to bathrooms. You're set up, and that's actually trying to solve the problem. Saying yes here, no here is better than saying no everywhere, but it's still just managing the problem. It's managing it better, but it's not solving it. So I'm okay with the framework that the chair has suggested. It's similar to what I had proposed. I'm still, however, uncomfortable with the phrase in totality and the answers on whether or not there's an as-applied problem. So I very well may support this at council, but for the time being, until I get some more clarity from city attorney on those things, I can't yet vote yes, because while I think this would be an improvement over what we would otherwise do, I'm just not sure we're legally defensible enough yet.
Councilmember Dave Michelson with City Attorney. We're happy to provide that clarity. I think what we'll find is the phrase "in light of all the circumstances" and the totality it's standard in the application and enforcement of laws. So whether it's actually written here or not, I still think that's the standard that the court uses, but we will absolutely look at that and get that confirmation one way or another for you.
Mr. Price.
Thank you. Thank you for the report. I'm prepared to support the chair's recommendation. I agree with my colleague. It certainly is better than nothing, better than what we have. It is a step. It certainly does not address all the concerns that exist, but I think it is it's a beginning framework from which obviously lots of discussion still will occur, but hopefully a path that will permit us to be responsive in a way that will help those individuals in need. And so, Mr. Chairman, I support your effort, and I'm prepared to vote in support of it at this point.
Thank you so much.
Thank you very much, and I too support the framework you've proposed. I certainly do not support a citywide ban. We need to provide some options for our homeless population, and this attempts to strike that balance with sensitive uses and to provide those options. I just wanted to make clear with the warning, is that like a report back to see if a warning is possible, or is that part of the recommendation you're making for the ordinance?
It is part of the recommendation we're making for the ordinance.
Okay, good. And I think that will help alleviate some of the spiraling into the additional debt for many of our homeless individuals that simply they cannot pay. So it'll help. Thanks.
Thank you so much, colleagues. And I appreciate your support, as well as appreciate Mr. Bonin's very thoughtful and ethical and progressive questioning of this policy. On the one hand, I do want us to be clear as a committee and clear in our deliberations. we do want to tell Angelenos who are fortunate enough to be housed that we're not going to have a policy that says someone can park their car in front of your house and live there. That is off the table. No one's considering that at all. At the same time, we know because we ban parking in front of people's houses and schools and parks and places where people are doing businesses, that people nor their cars are going to disappear. They have to, I mean, physics just tells you it has to go somewhere. And so what we put forward today tries to strike a balance. Again, I think it's still not what we need and where we want to land, but it is closer to where we need to be than where we've been. So with that, Mr. Clerk, do we need to do a roll call?
Yes, sir.
Okay.
Oh,
I'm sorry. I have one comment card before we vote that I overlooked, and I apologize. Mr. Scott Sale for 1 minute.
Thank you very much. Scott Sale, Leo Beck Temple, and CD5 and the Midtown Homeless Coalition. I appreciate all of the comments and where you're trying to go with all this now that I get to talk after you've had your discussion. So I appreciate that. What strikes me still bizarrely is why would we even have an ordinance before we have a place for people to park? So why don't we do the safe parking first, let the ordinance just lay in the cobweb somewhere, and then do something that tells people in Los Angeles that we're not going to allow everybody to park in front. That's number one. Number two, we have this bizarre, these hours that we're talking about when people can park and when they can't park. I was just thinking, theoretically, if we offered people jobs at night, then theoretically they could sleep in their cars during the day. So if we had jobs for them, which is bizarre because we don't have jobs. So anyway, I mean, it's just kind of bizarre. But so please get the safe parking program going and just leave this 8502 alone for a while, please. Thank you.
Excellent. Thank you so much. Mr. Clerk, you want to call the roll? I'm sorry, Mr. Bonin has an additional comment.
Even though I'm not ready today because of questions from with the city attorney, I do want to say I support the framework you've proposed, and that's not where my qualms lie. And I do want to say, as the person who's been pushing the hardest, and some of my colleagues, not the ones on this committee, might say most annoyingly for safe parking, I certainly think it would be much better to have safe parking in place first, but to be saying that a huge percentage of the city is a place where you can park and you will not be subject to penalty is a huge leap forward. It's actually doing both things simultaneously. It is saying yes in places, and it's saying no in places. It's not saying yes with benefits and a pathway out, but it is saying yes in some places, which I think is a credit to the framework.
Thank you so much, Mr. Bonin. Mr. Clerk?
So we're going to do a roll call on the recommendation set forth by the chair. Mr. Price, is it a yes or a no? Yes. Yes. Mr. Wizar?
Yes.
Mr. Dawson?
Yes.
Mr. Bonin?
No for now.
It's three.
So that'll be the order. Do we have any other business before us, Mr. Clerk?
That clears the desk, sir.
Excellent. We're adjourned. Thank you.